Thank you. In that case, let's switch to the next panel because it's also important. We can't take a break. We can't afford it because we are behind schedule right now. So let's move on because we have more in the pipeline. I thank all the speakers, and now we understand that we can talk to kids about mediation with young people. And this is indeed fertile ground instead of convincing an adult or experienced professional.
Thank you. So let us now move to our next panel discussion. Nataliia, are you with us? Oh, right there. You're there. That's great. Nataliia, I want to introduce you and then hand over the floor to you. Nataliia Mazaraki, if you don't know her. However, I don't know how you can not be aware of who Nataliia is because she joins our forum every year as a moderator and as a speaker as well. Nataliia is part of our Ukraine Academy of Mediation's team, but what she does primarily is working at the state economy for commerce, where she is the chair of the desk. And she is a renowned scholar in mediation because she was the one to defend her PhD on mediation among Ukrainians. And at the same time, Nataliia does not want to pass any mediation training to maintain this kind of scientific neutrality. Over to you, Nataliia. Dear participants, I'd like to welcome you, everybody here. Luisa, thank you very much for the warm words. I'm also very happy having this opportunity to be working with you, with the team of the Ukrainian Academy of Mediation, because we put together so many different people who not only try to keep mediation growing, but they're doing the job with love, passion, and motivation. They also build understanding of what's needed right now, what's going to be necessary in the future. Today, our panel discussion is dedicated to some very relevant issues, and the topic is great. Luisa has already said a couple of minutes ago that she is in the United Kingdom right now. Part of our audience is right now in Ukraine. The number of countries where our participants and speakers come from is just dozens and dozens of different nations. So I'm so happy to welcome you here at our panel discussion, Mediation Beyond Borders, Resolving Cross-Border Disputes in a Globalized World. And we don't do this within Mediation and Law Forum. We now live in the world where borders can only be seen on maps. But in the agreements that we sign, in commercial relationships or interpersonal relations, we have no borders at all. From commercial projects to family cases, from development contracts to international partnerships. Conflicts more and more tend to go across different languages, cultures, nations. And in this respect, cross-border mediation becomes not an exception, but a pressing need. I'm so glad that we have now an opportunity to listen to our three renowned international experts who not only deal with cross-border mediation, and you will see this and hear this right now. They build this practice and build cases all across the world. We have Gary Birnberg from Brazil. He's an arbiter and mediator who specializes in cross-border commercial disputes, and he's been working in English, French, and Portuguese. We have Corrado Mora a mediator with over 20 years of practical experience in most difficult cases and in training mediators across so many different countries. And we have Katarzyna Przyluska Ciszewska from Poland. She is the lawyer, coach, mediator, and a designer of dispute resolution, certified mediation trainer. So altogether, our speakers and we, by the way, all of us, will talk about what makes cross-border mediation so special, how to build trust between the different parties coming from different countries and legal frameworks, what skills are needed for this state-of-the-art contemporary cross-border mediation. I encourage you to join our in-depth and topical discussion about how mediation goes beyond borders and beyond territories and geographies. However, beforehand, just a little bit about housekeeping, since I'm the moderator for this session. Each of the three speakers will have up to 25 minutes for their presentations, interventions, etc. After all the speeches, we will run a Q&A session. That is why, dear participants, please leave your comments and questions in the chat during the panel discussion, whether you're going to be able to ask it in person, out loud, or not. But please make sure you type your questions in the chat. Otherwise, you'll be given the floor at the end to be able to voice your questions. We're gonna try to give this opportunity to as many participants as possible. I'm so grateful to the organizers, technical supports during this forum, which makes this event really cross-border. And of course, our speakers. We're going to be following the agenda that is mentioned in the program that we shared with you already. And it is my pleasure and honor to give the floor, oh, I beg your pardon, to Gary Birnberg. Just a bit about him, a little bit about Gary. Gary is a mediator, arbiter with vast experience and renowned reputation, with so much experience of resolving cross-border disputes. He's the member of one of the leading international organizations called GINS, because he is one of the leaders in ADR. He comes from Brazil, and in his own practice, he really uses international cross-border approaches and techniques because he can speak 3 different languages. He could handle cases in so many different jurisdictions, in so many different legal frameworks and across cultures. He specializes in commercial, corporate disputes, financial issues, development, IPR, international commerce. His background was in so many different legal frameworks, both continental and Anglo-Saxon law. Gary has been actively working with parties from different legal traditions, and he can sense cross-border communication nuances that he's going to talk about today. Beyond his practical activities, he's been doing so much to develop conflict resolution infrastructure. Being a practitioner in Europe, in North and South Americas, in the Americas, and also both in mediation and arbitration. That is why, please welcome Gary. Let us welcome Gary Birnberg all together, who will share some information about cross-border mediation.
Gary, the floor is yours for up to 25 minutes.
Thank you so much, Nataliia, for that very generous introduction. It's an honor and a pleasure to be here with you today, with the other speakers, Corrado and Katarzyna, whom I'm honored to be among as one of the speakers, and so many participants. Thank you all, and I intend today to give to you a layered presentation. The whole question of the influence of factors that can be found in multinational mediation is vast. It's absolutely vast. And I want to try first of all, to give a basic theoretical framework, not necessarily linked to mediation, but I'll try to link it to mediation anyway, but just a framework from which we can start as a baseline to analyze situations and to use as a contrasting feature for what we might find in cross-border mediation that we might not be able to find, or that we might not otherwise find in domestic mediations or non-complex mediations. So I'll start with a theory. I'll give some potential applications of different aspects of the theory. And then I'll go on to speak about some of the cases that I've been involved with that either reflect the basics of the theory or that go completely astray from it. It's useful to see how things work positively, negatively, fit with the theory or don't fit with the theory. So hopefully, I certainly hope to give you an engaging presentation today, and one which will spark some interest. So let's start with the theoretical part. And in this theoretical part, I'm relying on the work of a scholar on cultural divergences, let's call it. His name is Geert Hofstede, and he's developed a cultural dimensions theory. And by the way, I'm giving you my interpretation of his theory. It may not be accurate, but it is. What I can say is that it is. I'm giving you what I find to be relevant in my realm of dispute resolution. So hopefully I'm not saying anything which is outside of what he said, contradicting what he said. I'm going to do my best. So his cultural dimensions theory, as he speaks of, it provides a framework for understanding how cultural values can influence behavior, communication, and conflict resolution. The theory identifies 6 key dimensions that describe national cultures. These dimensions can help mediators, or for that matter, business leaders and others, to adapt to cultural differences. So I will go through a summary of each of these dimensions. Again, as I said before, followed by an application of dimensions to nations and cultures that typify the polar extremes of each dimension, and then examples of how the dynamic of each of these dimensions might manifest in commercial mediation. Before going on again to my individual experiences, my war stories, as we like to call them in the profession. So, the first dimension, it's individualism versus collectivism. This dimension, it refers to the extent to which individuals are integrated into groups. In individualistic cultures, people tend to prioritize their personal goals and autonomy. In contrast, in collectivist cultures, individuals are more likely to prioritize group goals, loyalty, and relationships. So, in cultures with high individualism, people are expected to look after themselves and their immediate families. There's an emphasis on independence and personal achievements. Characteristic of high individualism nationalities are the United States and the United Kingdom. Then, in contrast, there's high collectivism, where individuals view themselves as part of a larger community, such as their extended family or work group, and maintain strong loyalty and interdependence. Now, though, typifying those cultures would be China and Japan as examples. And so here's how this might play out in a mediation situation. Let's imagine that we have a United States technology entrepreneur who's negotiating a joint venture with a Japanese manufacturing firm. The American might focus on contractual terms, personal incentives, individual ownership of intellectual property, while the Japanese team may emphasize long-term partnership, shared responsibility, and consensus. So the challenge in the mediation is for the mediator to address the different expectations about the negotiation process. The American may perceive the group-based decision-making of the Japanese as evasive or indecisive. While on the other hand, the Japanese team may view the Americans' assertiveness as selfish or disrespectful of the group's harmony. The mediator then needs to foster mutual understanding around decision-making norms and suggest phased agreements that respect both individual responsibility and group consensus. And I state something here which will be characteristic to each of these theories. I'm placing the responsibility on the mediator to individually overcome these challenges. When we look at mediation, the mediator has to take into consideration the situation in front of him or in front of her, address it, and find a way to bring people together, find a common understanding. And this clearly is something which here means addressing some of these challenges. The second dimension, power distance. This measures the extent to which less powerful members of a society accept and expect power to be distributed unequally. In high power distance cultures, hierarchical structures are accepted and respected, and authority figures are given deference. In low power distance cultures, power is more evenly distributed and equality is valued. So high power distance cultures in which people accept a hierarchical order without much question will be Mexico and India as examples. And low power distance structures would be where structures are flatter and equality among individuals is emphasized, would be Nordic countries such as Denmark and Sweden. Here's a scenario. A Danish logistics company is in a dispute with its Indian supplier over missed delivery deadlines. The Indian team will insist that communications go through top leadership and defers decisions to senior management, while the Danish manager speaks directly to junior staff, expecting transparency. So in mediation, the challenge is for the mediator to bridge the hierarchical expectations. The Danish team might see the Indian approach as inefficient or evasive, while the Indian side may perceive the Danes as disrespectful of protocol. A solution then might involve agreeing to a dual communication track, formal reports through leadership with informal channels for operational issues. Speak to both parties simultaneously. The third dimension, uncertainty avoidance. This dimension reflects a society's tolerance for ambiguity and uncertainty. High uncertainty avoidance cultures have strict rules, regulations, and clear structures to minimize uncertainty. Low uncertainty avoidance cultures are more comfortable with ambiguity, risk-taking, and adaptability. Among societies that demonstrate high uncertainty avoidance, in other words, they have a low tolerance for uncertainty and ambiguity and rely on rules and planning to mitigate risks, would be Greece and Japan. Low uncertainty avoidance cultures, where people are more relaxed about uncertainty and take more flexible approach to it, Singapore and Denmark. A scenario then, a Greek franchisee and a Singaporean franchisor are disputing over how to respond to market disruptions. The Greek partner insists on detailed contingency plans and contractual safeguards, while the Singaporean prefers agile responses and views rigidity as a liability. So the mediation challenge is for the mediator to reconcile the Greek desire for risk mitigation with the Singaporean's preference for flexibility. Clarifying thresholds for when flexibility ends and predefined procedures begin could help. The mediator might suggest a tiered response protocol, predefined plans for predictable risks, along with flexible strategies for novel challenges. Again, speaking to both. The fourth dimension then, masculinity versus femininity. This dimension refers to the distribution of emotional roles between the genders. Masculine cultures value competitiveness, achievement, and material success. Feminine cultures prioritize relationships, quality of life, and caring for others. So, high masculinity cultures emphasize achievement, heroism, assertiveness, and material rewards for success. And cultures that prize this are Japan and Germany. High femininity cultures place more value on cooperation, modesty, and quality of life. Again, the Nordic cultures, such as Sweden and Norway. And here's a scenario where this might play out. A scenario, a German high masculinity engineering firm is mediating a commercial dispute with a Swedish design partner. The Germans prioritize performance metrics and success milestones. The Swedes, however, focus on employee well-being and maintaining a collaborative tone. The mediation challenge becomes recognizing that the German side might perceive the Swedes to be lacking drive or motivation, while the Swedes might view the Germans to be aggressive and dismissive of human factors. The mediator can encourage, then, redefining success to include both performance and process metrics. A hybrid performance review model could, in fact, reconcile the results-driven and relationship approaches. Bringing together the priorities of both parties in that situation. The fifth of our six dimensions are long-term versus short-term orientation. This reflects a society's attitude toward time and the importance it places on tradition versus future planning. Long-term oriented cultures are pragmatic, value perseverance, and a focus on future rewards. Short-term oriented cultures tend to value traditions and immediate results. Long-term orientation, again, focus on future outcomes, would be typified by cultures such as Chinese and South Korean. In contrast, short-term orientation and focus on respect for tradition, maintaining could be the United States and others. A scenario here could be that a Chinese company, conglomerate, and a U.S. startup are mediating a disagreement about expected deliverables. The Chinese side may be willing to invest heavily for gradual results. The Americans, however, insist on rapid returns and short-term profitability. So the challenge of mediation is for the mediator to recognize that the U.S. party may see the Chinese as slow and overly cautious, while the Chinese may see the Americans as impatient and short-sighted. The mediator then could propose a timeline that includes early benchmarks to satisfy short-term needs while embedding long-term goals, aligning expectations across diverse time horizons. The last dimension is indulgence versus restraint. And this dimension reflects the extent to which societies allow for relatively free gratification of human desires. Indulgent cultures encourage enjoying life and having fun. Restrained cultures have stricter social norms and regulate gratification of needs. High indulgence societies that encourage free pursuit of enjoyment and leisure will be typified by the United States and Australia, while high restraint cultures that societies that are more controlled and regulate personal desires through stricter social norms might be China, and perhaps even, and you'll correct me if I'm wrong about this, the Ukraine. A scenario in this case might be in Australia, and again, a high indulgence marketing agency that's working with a Ukrainian client, and they're clashing over campaign style. The Australians may propose bold, humorous, emotionally charged ads, while the Russians might insist on conservative messaging, citing cultural appropriateness and regulatory constraints. And here in the mediation challenge would be that the mediator must recognize that the Australian team may interpret the Ukrainian caution as outdated conservatism, whereas the Ukrainian side may view the Australian tone as reckless or inappropriate. The mediator might explore compromise through segmented messaging strategies, targeting different tones to different markets or audiences, and educating both sides on underlying cultural values related to expression. So that's my take on the cultural dimensions on the cultural dimensions theory. Now, let's look at some examples that I've lived through in my work as a mediator. And again, they may not necessarily line up perfectly with these cultural dimensions. They may not line up at all with the cultural dimensions, but it's very important in my mind to have these cultural dimensions in mind in going into a mediation, particularly if you might be a mediator, because these are the categorical sorts of things which are repetitive and which you can expect to play a role in a cross-border dispute. So my first example had to do with a dispute between an entrepreneurial company which was formed. The company was an American company, a U.S. company. Its founders were a mixture of Americans, Israelis, and there was also a Palestinian involved in this wonderful mixture of people. The relationship that had already been cemented between the two of them before this question went to dispute resolution was that the conglomerate, which was a Japanese conglomerate, had already acquired the entrepreneurial company. And the company, what it did was it had several products that addressed the irregularity, I suppose you can call the challenge that many people have of sleep apnea, problems with breathing and with heart rate during sleep. And they developed several, shall I say, devices that are to be used in the mouth while sleeping sort of a retainer sort of thing used during the nighttime. So the Japanese company had already acquired this American Israeli Palestinian company, and in the contract for acquisition, there were two phases to the deal. The first phase to take place upon signing the contract was the actual transfer of ownership, together with the payment to the entrepreneurial company which was being acquired. The second phase occurred a year later, when there was to be an evaluation of the value impact of the acquisition on the Japanese acquiring company's business activities. And the Japanese, not because they're Japanese, but because they were perhaps the acquiring entity rather than the entity being acquired, they took the position that the results were minimal, that they did not reach the threshold required for any second phase payout. This, of course, this very notion offended the entrepreneurial company, which in fact gave tremendous blowback. And their argument was a rather individualistic argument, and that was that the Japanese company had quashed the opportunity for the acquisition to have a palpable, measurable, objective impact on the business activities of the company within that sector, because of the very absorption of the company. The absorption of the company, in effect, what they argued was it was a ruse, or the second phase was a ruse. The acquired company was never meant to have an impact on the bottom line, or a business impact as an entity, or as a semi-autonomous entity, which is what they believed. Rather, it was meant to eliminate a competitor in the marketplace. In effect, we see a certain level of the entrepreneurial company looking individualistic. They wanted their payout, while the collective company while the Japanese company, the acquiring company, the conglomerate, looked at this as being a very successful acquisition for everybody. And in essence, what they saw, the way that they looked at this situation was, where's the problem? Where's the problem? We had a contract. The metrics were not met to release a second significant payment. So what are you complaining about? We've built a better business together than we had separately. So that was very interesting. In the end, what happened was the mediation ended up in an impasse, and the matter went on to arbitration, where the result was what it was. And if I understand correctly, the result was that there was no second phase payment. So moving on, I want to speak now about a case that I had that had to do, and this was a really fascinating case. So it's not something that you would necessarily expect to see in mediation, but it was a dispute between a Brazilian telecom company that was seeking an IPO in the US market. They had an inexperienced team. Oh my, the time is up.
Diego, maybe some minutes. I'm eager to know about this case as well as our participants.
Okay, great. Thank you. And my apologies for going over here. The dispute was between this company doing a stock offering on the U.S. exchange, a Brazilian company in the U.S. doing this in the U.S. Their dispute was with their investment bankers, their American investment bankers, who were to manage the launch of the company on the U.S. stock exchange. And the problem there was that the investment bankers were unable to extract from their clients the information that they needed for regulatory purposes to be able to provide to the proper U.S. authorities in order for the stock to be delivered or to be launched on the exchange. And this was quite fascinating because it was a result of two things. One is a linguistic gap. But the second thing, which was absolutely fascinating, it was because terms that are utilized in the United States in public offerings were very different from the terms and that were needed in order to be signed up for these, were different from the terms that were used in Brazil in a civil law country regime. The documents were different. The documents were not the same, and there was no translation between what the U.S. investment bank needed and what the Brazilian company had as documents. So my role mediating this conflict was in essence not to translate between one and the other of the two partners. It was to interpret and to have a constructive interpretation of the groups of materials that were needed and how the translations of those materials required to be set up in order for the investment bank and their attorneys to be able to meet the regulatory requirements for a stock launch in the United States. Should there be time at the end, I would be happy to give a couple of other scenarios, but I will be respectful now. And again, my apologies for going over. And thank you all for your attention.
Дорогий Гаррі, я дуже дякую за цю чудову презентацію. Я на кожному прикладі...
Dear Harry, thank you for your presentation. During your narrative, I was thinking of myself, which group do I fall into, Can you hear the interpreting?
Гаррі, do you hear the translation?
Yes,
Can you hear the interpreting?
Yes, thank you.
Чудово, я знаю, що наші перекладачі чудові. І я, коли слухала, я намагалася зрозуміти...
As I was listening to you, I was trying to understand, okay, what is my worldview? Where do I fall into? Like, which pigeonhole would I fit in? So you opened my eyes on many things. So thank you for your wonderful presentation. And indeed, I will ask you some questions at the end when we get to the Q&A stage. And now it is my pleasure to present to you Corrado Mora, our next speaker. He is a mediator, well-known worldwide, that with experience of mediation. Mr. Parada was involved in complex disputes. He's been training globally and serving on top of international mediation institution panels. He mediated in consumer disputes and other types of disputes. Now, what is different about Mr. Corrado is that he knows how to work in different legal systems and cultures, which makes him one of the top mediators in the world. Besides, Mr. Corrado is a trainer in negotiations and alternative dispute settlement. He's a professor in the University of Trento, and he is often invited to universities throughout Europe and outside Europe. Mr. Corrado also consults and works as an expert in organizations such as UN, USAID, European Patent Bureau, International Institute of Mediation, etc. He was involved in large number of projects dedicated to mediation, including school mediation. Now, when I read Mr. Corrado's biography in order to prepare for presenting him, I was very impressed. I couldn't imagine how one person, one man, can combine so much within one personality. So today, Mr. Corrado will talk about designing the process of transborder mediation and will share his view on how the process can be how mediation can be used, including online. So let's give him a round of applause and welcome him.
The floor is yours for the next 25 minutes, and we will set up the timer, and you will hear beautiful music signalizing the time is over. Many thanks, please.
It was beautiful indeed. Well, thanks so much, Nataliia, first of all, and thanks so much to the Ukrainian Academy of Mediation. Thanks a lot for organizer having me, Gary, for your wonderful presentation, as I'm sure it will be Katarzyna's. Great to be in the panel with you. So when we think of cross-border mediation, we immediately think of legal complexity, jurisdictional overlap, and cultural diversity. But increasingly, what distinguishes successful cross-border mediations is not just the mediator's skills, but it is the design of the process itself. And today, that design is profoundly shaped by technology too. So yet before all that, it is worth remembering something fundamental. Mediation is mediation, and no matter where you perform it around the globe. So unlike arbitration or court proceedings, which are shaped and often constrained by procedural rules, governing laws, or national frameworks, mediation maintains a unique consistency across borders. Even when local norms or laws, such as domestic mediation acts or international instruments like the Singapore Convention, come into play, they don't redefine what mediation is, luckily, because ultimately what defines mediation is not the external legal context, but the process the mediator co-creates with the parties. This process, which is flexible yet familiar, typically includes joint sessions and private meetings, informality and inclusiveness, and a careful attention to the substantive, business, relational, and emotional dimensions of conflict. It is built around effective negotiation and, where possible, the rebuild of trust and relationships between the parties. This underlying structure and potential shape of mediation is remarkably stable, no matter the jurisdiction. That is what makes mediation unique and profoundly reassuring for parties and their advocates. It offers a process that, even in unfamiliar territory, somehow feels like home. I'd like to explore how we as mediators and dispute resolution professionals can tailor the mediation process and specifically use technology, not merely as a tool of convenience, as we came to use it under the pandemics, for example, as we are doing now, for being together in these circumstances, but as a core enabler for well-designed, adaptive, and inclusive mediation processes around borders. So why process design matters more in cross-border contexts. When we talk about cross-border mediation, we often frame it as a tool for resolving disputes between parties in different countries. But in my experience, cross-border mediation is never just about resolving a dispute. It is about navigating a complex landscape, layers of legal frameworks, linguistic barriers, logistical hurdles, and not least emotional dynamics. This complexity doesn't paralyze us. It pushes us towards intentionality. It demands from the mediator not just flexibility, but deliberate design. That's what I want to focus on today. So how and why, as mediators, we need to design the mediation process with care, especially in cross-border contexts. So let me start with an example. I will try to put here and there some examples that I managed as a mediator. And as Gary offered, I can really go with more in the Q&A session afterwards. So let's go with the first example. So a few years ago, I mediated a dispute involving a European tech firm and an Asian manufacturer over intellectual property rights related to a medical device. The contract had kind of a vague jurisdiction clauses and conflicting interpretations of patent scope under EU versus Asian IP law. It was not very well designed, I would say, from a legal perspective. From the outset, we weren't just managing a legal disagreement. So it was not just a matter of the contract and its complexities. Indeed, we were navigating two distinct legal regimes, intense distrust between the parties due to previous cease and desist letters and all that created when conflict came around, a logistical challenge. The clients, their lawyers, and IP experts were very simply but very complexly spread across 5 time zones around the globe. So had we tried to squeeze these into the typical in-person, one-day, shuttle-style mediation procedure, we would have failed, I think, much before we began. Or we would have just had the parties not very comfortable during the mediation process, which is kind of a must, I think, for each and every mediator. So instead, we had to rethink the process from scratch almost. So why structured process design is critical? Let's unpack a few of the key reasons why a structured, custom-designed mediation process is not just helpful under these circumstances, but I would say essential in much more than, well, I would say almost always cross-border mediations. Again, juridical complexity. As I said, cross-border parties operate under different legal systems, procedural norms, and enforcement regimes. In the IP case that I just mentioned, parties had different understandings, for example, of what settlement even meant. One expected court approval as a matter of course, and the other one considered it optional and even invasive. So we had to build a timeline that included legal consultation windows between the parties and their advocates, and make room for comparative law briefings, essentially kind of mini workshops that we organized during the mediation to ensure alignments and somehow kind of a translation and not misunderstandings and clearliness and transparency between legal systems. In another case, a dispute over the dissolution of a joint venture between a US investor and a Brazilian company required input from counsel in 3 jurisdictions. We built a multi-phase process with pauses for legal analysis, so no party felt blindsided by unfamiliar procedural norms. We talked about legal complexities, and I'm a big fan of keeping legal aspects not on the podium of mediation topics to be analyzed. Most often they just bring to positional differences and the parties far away from each other than towards resolution. But of course, they also want to understand what's going on, and they want to understand as parties and as lawyers what happened creating the conflict. So giving this kind of space and mutual understanding of the legal aspects of the dispute can really help them getting comfort and perhaps more understanding of the situation. Second aspect is time zones and geography. So when your mediation participants are in Singapore, Frankfurt, Milan, and New York, so even scheduling a call really becomes a negotiation. In a complex licensing dispute that I mediated last year involving an Italian pharma company and a US research institute, we conducted shorter, staggered sessions across several weeks instead of trying to cram everything into one extended session. And when I'm talking about session, I mean online sessions. So here is one of the big uses of online mediation, I think, which really makes possible the impossible. Sometimes it is just impossible for the parties combining their agendas for finding time to sit around a physical table together. Some other times it is just impossible for collecting a huge bunch of people which constitute a party. Some other times in some other situation, it is just impossible to have someone around the table because they are physically impossibilitated to sit around the table. So the modular structure, which I've just mentioned and I created during that process, allowed for better preparation, reflection between meetings, and importantly, avoided midnight calls that would have added stress and fatigue to already tense conversations. So it was a kind of a step-by-step mutual understanding, not just in a round, which could have become tense and difficult, but again, allowing time both for dealing with time zones and helping them getting perspective, understanding, preparation in between the meetings. So third point is cultural expectations. Culture shapes how we interpret fairness, hierarchy, silence, whatever thing is around a mediation table is really framed by our culture. And sometimes I would say almost always we don't even acknowledge that. We just see things as we see things without even understanding that the way we are seeing things, it is just because of our experience and our culture. In a business dispute between a Nordic company that I mediated and a Middle Eastern distributor, the Nordic side expected full transparency upfront and rapid decision-making. But the other side needed time, consultation with senior figures not directly at the table, and valued discretion and indirect communication. So we had a Formula One, very fast car, and a very slow-paced traditional machine. So what I came across as a kind of a process design with them was a kind of a two-track format. So we had confidential caucuses with decision makers and open sessions with spokespersons. This helped preserving face and allowed both sides to engage meaningfully with their cultural norms. So having sessions, packing within one session, decision makers, sometimes spokespersons, some other times, many other times just the lawyers, when it all allowed this kind of different paces around the table to be not just respected, but to have a kind of clarity and mutual understanding without just distress. So without that adaptation, I think that one party would have seen the other as evasive, perhaps. So never giving responses, never coming to decision maker, while the other would have had seen their counterparts, the Nordic counterparts, as pushy or disrespectful. So I think it means something that is not just connected to today's mediation situation, when we just think about what happened with transformative mediation, for example, in the 80s. It really looked like an earthquake, and the usual caucuses mediation, the usual shuttle mediation, which was the standard model, which was used and trained around, really got shaken by, for example, transformative mediation, which was presented by Bush and Folger, which required parties being together always, all the time, for them to get mutual understanding through empowerment and recognition. So it's not something very new. But I would say that more and more the traditional model of mediation, which again usually has been seen like people packed together for one day into one room from morning to midnight, being in person, physically around the table, shuttle style format, well, it is increasingly unfit for purpose in cross-border disputes. What need to custom tailor the structure? So we need to custom tailor the structure. For example, the pace. Do parties need breaks between sessions for internal consultations, translations, or legal review? Many times it is. We don't have to expect the parties are just very ready to listen to the other one, both substantial and perhaps subjective and technical aspects that are coming from the other side of the table, and very ready to interject it all, digest it all, and have some thoughts about that. So many times, pace must be somehow slightly longer and slower. So sometimes parties do need breaks between sessions, and it may need more than just one meeting. Again, you can hear the sound of online mediation as being a bit easier to use for performing this kind of shorter, more targeted sessions when we think we may need this kind of breaks. The sequence. So should we front load with information sharing, start with side private meetings? Should we need experts in early or later? Again, it is not always the very same. Sometimes it is very useful, and I'm a big fan of that, having the parties talking about what happened and their conflict in the typical joint session at the very beginning of a mediation. But sometimes it is not appropriate because of the level of emotions, because of what happened between the parties, because of the kind of information which they are going to share. So perhaps in this situation, it can be more effective, not just for information sharing, but also for creating rapport with the parties, to start with caucuses. And again, sometimes I really had to mediate between experts, which the parties brought around the room. And it was not, I would say, low education experts. It was a matter of professors coming from big universities, which were used by the parties as experts. And they were in the room starting to really fight with even more emotional temperature than the parties were. And I had to do this kind of mediation within a mediation between experts. And it just reminded me how experts can be beneficial, but sometimes you really have to focus on when is the right time for having experts around. And again, it comes with shaping the process in the most appropriate way. The format should be online, hybrid, synchronous, asynchronous. This is not over-engineering. This is process design in service of fairness, clarity, and ultimately resolution between the parties. And I would say this doesn't just apply to cross-border mediations. Also domestic ones possibly involve complex layers of differences, multicultural aspects. People coming from the very same country may have very different backgrounds. So process design is paramount also in these situations. So when we talk about technology mediation, the conversation often starts and ends talking about video calls, Zoom meetings. But let me offer a different perspective. Technology is not just a way to deliver mediation at distance. It gives us entirely new materials to work with, tools to reshape how we design, sequence, and adapt the entire dispute resolution architecture. Let me just go through some practical ways I've seen this play out in cross-border mediation. So asynchronous phases. Again, I already disclosed how much I appreciate the informative and transformative potentials of an initial joint sessions, all parties together. Having said that, technology allows us to decompress time, and that alone changes everything. Bring you an example. In one commercial dispute I mediated between a Latin American supplier and a European distributor, we began not with a joint call, not with a joint meeting, but with pre-recorded video statements. Well, it is something that I would have never thought about, but that was the case, and really it expanded my view. After pre-mediation meetings I had with the parties for signing the mediation agreements, introducing myself, already creating rapport, and getting some hints about emotional aspects. For example, where I came to understand, and it was not very difficult, I have to say, they both openly discussed it with me, that the emotional level between the two was very, very high. Packing this information with complexities of the case, well, I suggested these pre-recorded video statements I mentioned. Each party had a week to prepare and submit their opening perspectives. So the other party was getting the video from party A and then reciprocated with a video with the opening statement. This asynchronous start had, well, strangeness for sure, but several benefits. It gave parties time to reflect, consult with advisors, and avoid being put on the spot. It for sure reduced anxiety. It helped them listen to the other party, which perhaps could have never happened if they were just listening to an in-person other party. So it reduced anxiety, especially for the party with less experience in formal negotiation, and the potential impact of a tense emotional confrontation. It allowed me, as a mediator, to absorb the emotional and factual contour of the dispute gradually, not all at once, for making it a good use, helping the parties then. And in another case, I didn't use these pre-recorded video sessions. It was involving a tech licensing conflict. And what we used was written submissions exchanged through a secure portal within 10 days. So again, it was written very out of my standards, but given the aspects of that situation, it really helped them venting out all the technicalities and objectivity of the dispute, which was paramount for them. I knew that sometimes it is not very paramount for conflict resolution, just focusing on technical, objective aspects. But having gone through all these, document sharing allowed them somehow to vent out the need of sharing technicalities, and they were much more prepared then to enter into more personal aspects. Let's talk about another aspect after asynchronous sessions. It is synchronous sessions via video. Live sessions are still essentials, but we no longer need to think of them as a single day marathon. Again, people pack together for the whole day. Technology allows us to hold shorter, more focused sessions spaced out over time. In a recent cross-border sport dispute, we scheduled a 90-minute session over 2 weeks. By coincidence, it was the duration of a football match. That spacing gave everyone time to regroup, consult internally, and process the discussion. So synchronous, but not dilated in time. Video conferencing also made it easy to bring in all bound by confidentiality interpreters for just a portion of that require linguistic support, subject matter experts who joined briefly to clarify a technical point, in-house counsel or regional managers who couldn't have flown in for an in-person session, but could drop just for 30 minutes to the Zoom session. And these integrations would have been prohibitively expensive or just impossible in a traditional in-person format. Digital tools, which is somehow something very on the spot nowadays, AI and on. Beyond video, a growing range of digital platforms helps us as mediators, or could help us visualizing and co-creating the resolution process itself. We use, I remember, in a 3-party licensing dispute involving entities in Singapore, Canada, and France, a shared Miro board to map out the contested issues, identify overlaps, and highlight priorities. It was Google Docs with live commenting for joint drafting of the term sheets, and everyone was able to directly make suggestions, flag edits, and revise collaboratively, even outside of live meetings. And again, confidential breakout rooms and encrypted chats for going through confidential aspects. Again, AI doesn't replace mediation, but it can really help us if we use it in an appropriate way. Just consider how we are using now AI in just drafting contracts, giving some aspects, or now how we can integrate translation. Now we have a person translating, and he's doing very well, but we can also have AI translating for us, and it can be helpful for avoiding possible problems coming with translations. And just very briefly, I'm mindful it's just 10 seconds to the sound. I use joint session or caucuses via Zoom addressing technical aspects of the matter, followed by a reflection period with offline, it's time, with offline party counsel, expert discussions, preliminary online session to build rapport, clarifying issues, discussing the mediation agreement. So again, it is just a matter of us mediators becoming architects somehow more and more than what we have always been of the process, for using all the tools we have and technological tool too, for helping the parties feeling confidential, for feeling comfortable, or feeling that they are involved in a process which is not just a standardized process, but it is just fitting their issues, their concerns, for them to get involved and solve their disputes. Thank you.
Many things said, dear Corrado. I would be happy to hear even more from you, because your experience is unimaginable. Я дуже дякую за вашу презентацію. Я би ще хотіла би, звісно,
I thank you for your presentation. I wish we could, give you some more time, but unfortunately we have our schedule that we need to stick to. But during Q&A, we can still ask at least a question or two. Okay, now let me introduce to you our third presenter, with whom we are equalizing gender equality on this panel. Let me introduce to you Ms. Katarzyna Przyluska. She's a lawyer, mediator, system designer, and trainer, and conflict coach for various dispute resolution solutions. She's a mediation certified teacher. She's a practicing lawyer with 20 years of experience, and she prefers conflict prevention, especially in commerce, especially working with organizations in labor relations. Katarzyna went through training as a judge, then she became a lawyer, defense lawyer, mediator. And what I read about her, she believes that traditional court system often doesn't have sufficient tools to support people in conflict settlement. In 2012, she started to practice in mediation. So you can only imagine how much experience she has already since 2012. She believes that mediation can change relations. Over the past 10 years, she's been teaching mediation, both for defense lawyers, judges, and mediators from various countries. She also supports the idea of a court with several doors, and she believes that any person who needs mediation should have access not only to legal remedies, but alternative methods of dispute settlement as well. So, without further ado, it is my pleasure to pass on to Katarzyna.
You are going to post to our participants. I will share it on the screen as soon as you tell me to do so. The floor is yours up to next 25 minutes.
Hello, can you hear me?
Yes.
Okay. Hello, good afternoon, good morning, good evening, whenever you are. And I would like at the beginning, thank you to organizers for inviting me and having me here. It's a pleasure and really honor to be here and speak in this session, because the globalization and a human encounter in mediation is a very, very important topic for me. So it's my pleasure to share my reflection grounded on over 2 decades of experience as a mediator, trainer, advocate of humanistic approach in dispute resolution. And today I'd like to explore how globalization challenges our work as leaders in peace building and the legal professionals, and how through mindfulness and a human-centered mediation we can respond with integrity and empathy. Because of part of my job is a training of meditation and reflective practice for mediators and judges. So this is a concept of people-centered justice and, as I said, human-centered mediation. Globalization affects dispute resolution in a profound way, and legal systems must now engage with diverse languages, cultures, jurisdictions, and identities. This presentation is both theoretical and deeply practical. My aim is to share interfaces that I have encountered, especially in Poland and outside, and with our Ukrainian colleagues, and offer a way forward grounded in human connection. Foundation of today comes from many sources, but 3 of them I would mention. It's Jacqueline Moreno, French mediator. She passed 2 years ago, humanistic mediation approach, rooted in emotional truth and inner transformation. The second is a role of mindfulness and compassion in legal settings, emphasized by Leonard Riskin and Leila Love. And the third is Lens of Global Legal Complexity by Arjun Apandai, who reminds us that the law today is no longer territorially stable. When legal system clashes, and we can see it, it's not only international law, but European law, national law, Sharia law, indigenous norms, we face uncertainty. And as a peace builders leaders, we must navigate this responsibility. Tools like legal dialogue, coordinated jurisdictional mapping, and instruments like a Singapore Convention can help create a more coherent path. Culture is not just the food or etiquettes. It's a values, emotional expression, or even silence, as we heard before. Cultural misunderstanding derails conflict resolution. Intercultural literacy and humility, especially for judges and court officials, are key to maintaining procedural fairness across boundaries. Our language isn't neutral. Words carry emotions, histories, hierarchies. Often litigants or parties are not speaking in their native tongue. In mediation, we respond through silence, paraphrasing, and mirroring, which I will speak about more later, not to fix the language, but to hear what unsaid. Global disputes often involve structural inequities. Migrants facing corporations, women negotiating with patriarchal settings, compassionate facilitation and trauma-informed practices, and willingness to slow down the process allow justice to emerge more authentically. In many hate-state cases, time pressure erodes reflective space. The rush to settle often disrespect emotional or ethical realities. As mediators, we should protect the integrity of the process, even if that means resisting procedural shortcuts. Increasingly, parties carry hybrid identities, ethnic, gendered, and national. This can lead to inner conflicts as well, allowing narrative space, asking reflective, identity-affirming questions, restore wholeness. This is where mediation and the other dispute resolution processes become deeply human acts. Jacqueline Morino, which I would talk about later more deeply, speaks about 4 stages in mediation: presence, encounter, catharsis, and resolution. A mediator is not a technician anymore, but is a mirror, one who reflects, contains, and witnesses. And we as leaders in dispute resolution can embrace this model when guiding others and precising over transformation. Mindfulness is not about silence in a courtroom or during mediation. It's about presence. It's allowed us to remain centered under pressure and to respond rather than react. It fosters ethical clarity and builds capacity for difficult, high-stake conversation. When we combine mindfulness and humanistic approach to mediation, we gain a model that is both culturally flexible and deeply grounded. This is not a theoretical merger. It's a practical toolkit for mediators navigating complex legal and emotional terrain. As we know, globalization destabilizes, but mediation recenters. In times of complexity, we must return to human dignity, presence, and compassion as pillars of our legal systems. And I invite you to model this transformation, and I try to explain how it could look like. Globalization brings people from different culture, linguistic, and legal traditions into the same transactional or relational space. This often leads to, as we heard before, different communication styles, direct versus indirect, high context versus low context, conflict expectations of fairness, conflicting, authority, or even emotional expression, and misinterpretation of gesture, silence, or tone. A mediator in a globalized context must become a cultural translator, not just a process manager. Globalized disputes often span multiple legal systems, creating jurisdictional ambiguity. Where should the dispute be resolved? Conflicting laws, differing definition of contract, liability, or good faith, and the challenges in enforcing accepted agreement internationally. Globalization can exacerbate power disparities. Corporations versus individuals or local communities, wealthy versus under-resourced parties, those with legal literacy or cross-cultural fluency, and those without. This affects who feels safe to speak, who controls the narrative, and whether mediation truly provides equitable resolution. Globalized markets create high-speed expectations, pressure to resolve fast due to global contracts and logistics, and high risk of rushes or surface-level mediation to close the deal rather than deeply resolve it. This undermines the reflective and humanistic dimension of mediation. Parties often hold multiple hybrid identities, professionally global, culturally local, emotionally divided. This can result with internal conflicts within individuals or organizations and difficulty defining what resolution really means across diverse perspectives. And even mediation itself becomes globalized. Cross-border and online mediation on the air, hybrid mediation arbitration model, or global norms or standards like Singapore Convention on Mediation. This pushes mediators to learn new skills, intercultural competences, digital fluency, and international law, and adapt styles without losing ethical grounding and human connection. How the mediators can respond mindfully to those challenges? They can cultivate intercultural literacy, not just awareness of different cultures, apply mindfulness to stay grounded amid complexity and ambiguity, use compassion to balance power and restore relational dignity, and be flexible yet principled, holding space for multiple truth. So in this concept, the mediator is open, out of the box thinking, with curiosity and with the beginner's mind. How we can and how we might do it, it's another thing. When mediating across culture, mindfulness trains us to pause, notice, and release assumptions. It allows space for cultural humility, where we listen not to judge, but to understand. And mindful approach and mindfulness practices can support non-reactive presence in tense, culturally sensitive moments. The practice of not knowing as a skill, suspending judgments and assumptions, and be conscious about implicit biases, about the party's motives, which is crucial for multicultural settings. Compassion is not a softness, it's a strategic lens. In mediation, especially cross-border, international, or intercultural, compassion restores dignity and fosters trust faster than logic alone. Compassionate inquiry can help uncover root causes to cross-border conflicts that legal frameworks alone often miss. We can incorporate empathic reflection techniques to diffuse emotional escalation. And the very important part of this concept is the inner work, which enables us mediators to hold the space. Because we cannot hold space for others unless we are cultivated that space within ourselves. For me, the role of self-awareness practices in preparing for the sessions and for my neutrality, emotional regulation, and cultural resonance is crucial. How we can do it? By brief grounding and briefing practice, helping redirect and in highly charged international sessions. The second part of the possibility which I can use is silence as a part of the cross-cultural disputes and as a bridge. Silence, when intentional, is universal. It gives people space to feel respected, not rushed. Present silence become equitizer in multilingual or power asymmetric contexts. Mindful silence creates space for reflection, especially when dealing with parties from cultures where indirect communication is valued. Interesting concept is that the mediation itself, it becomes a third party to the conflict. In a globalized world, we are not just navigating between cultures. We are creating a new shared culture in a mediation room. So I like to offer the idea of creating third culture, the culture of mediation, neutral, respectful space held by the mediator and shaped by mindfulness rather than the cultural dominance. This can be especially powerful when there is a history of post-colonial imbalance or identity-based trauma in cross-border disputes. In cross-border mediation, I found that while law defined the boundaries, mindfulness and compassion define equity and quality for encounter that allowed us to humanize complexity and feel before we fixed anything. We know that the pain, the harm, the emotions and feelings are common, even if the disputes are cross-border. And as we heard today, mediation is not a technique. It's a way for me to heal the soul and to encounter the human cry. In this spirit, I think bringing mindfulness and compassion into cross-border mediation to foster a space when the inner lives of participants matter as much as the external resolution. And the concept of human cry, and meet this concept by Jacqueline Moreno, brought to mediation by Jacqueline Moreno, is quite interesting. Because Moreno teaches that humanistic mediation is rooted in active listening and empathy and not a structured process. But at the same time, she compared this process with the Greek tragedy. So the concept of the Greek tragedy and the mirror she invites to the mediation process consists of some stages. First of all, the parties meet voluntary, then they confront their pain, they, with the help of mediator, then transcend, and then there's a liberation or catharsis, which comes with the resolution. And there is a mirror technique when the mediator reflects feelings back, simply witnessing without interpreting what was said. And this concept is quite special because mediator reflected by saying, I feel. And then we can see that in cross-border disputes, every person as a human being get the same feelings, and the feelings are common for every human being. So naming the feelings brings this kind of a soft eyes approach and help to hold the space with not judgmental awareness. Then comes with the process with the silent pause, and the concept of humanistic mediation in cross-border disputes are very powerful because it comes with the mediator as a witness who listen, hold a space, and validate silence. Then what is very interesting as a part of the process is the inner work of the mediator. So as I said at the beginning, I'm meditation and reflective practice teacher for mediators, I can say and emphasize that the mediator become during the process as a reflective catalyst, as a mirror, and to hold that space, it's very important to be prepared and practice daily self-reflection and or brief exercise or the other rituals or grounding to cultivate neutral presence and compassionate attunements. And for that reason, there are some examples how mediators can, in this context, start the session. One of the examples is, let's begin with the moment of stillness. Take a breath together as you speak. I will listen not just to what you say, but how it lands in your body. My role is to reflect, witness, and hold space, compassionately and without judgment. I believe that is a little different approach to cross-border disputes. But now I invite you to, if you are open to it, to answer the questions which I provide before the session. And there are two, if it's possible to put it to the chat.
I was speaking and with my microphone muted, so here are the first question in both languages.
Do you have it? I'm sorry.
Yes, we have it in chat now.
Okay. So I invite you to just, sit in silence for a minute and just reflect on that questions. What does it mean to truly meet in mediation someone whose word is built differently than yours? You can journal it, you can write it down. It might be, kind of experience with yourself. The first, or maybe not the first one, about reflection about your feelings as a mediator. And there is the second question.
People keep texting that this is an opportunity to expand your mind, to learn something new, broaden your outlook. And there are some more in English.
I think we can record the chat too. And the second question, which I invite you to reflect, is how does sitting with your own heart space or engaging others transform the way we listen, reflect, and mirror in cross-border settings?
Some people write, this brings you new angles to your experience. This can be a challenge for you because your values, things that you're convinced in, life experience, vision of justice, logic, response mechanisms to the conflict can vary from other people, and you need to acknowledge this and set priorities accordingly. That's just one of the comments here in the chat.
Thank you. So at the end of my session, I just want to emphasize what I said before about the borders and the common grounds. So borders for me divides, courts divides, and conflict divides. And I think mediation and reflective practice, compassion and mindfulness unified. Thank you.
Many thanks, dear Katarzyna. Your speech and your questions made me to think over and to once understand that mediation is very deep for one to comprehend it in a full. Я дуже дякую пані Катарzynie
I want to
за
really
її
thank you, Katarzyna.
презентацію.
Dziękuję bardzo for your intervention.
Її
And thank
тези
you
примусили
for
нас,
sharing so much knowledge and experience. This is thought-provoking, and we got convinced once again that mediation is rooted much deeper than one can comprehend at the first glance.
Шановні учасники,
Dear participants,
шановні спікери,
dear speakers,
мені, до речі, дуже приємно
I feel so nice because our people are so active in the chat right now. It demonstrates how people here want to dive deeper into this issue and try to give their own answers. Sometimes some of the answers are quite unexpected for me. But anyways, I'd like to thank all the participants, and we're gonna again express gratefulness to Katarzyna for sticking to the timing. We still have time for questions and answers. I want to also thank the Ukrainian Academy of Mediation's team for supporting our forum, and thanks to me thanks to them for helping me as moderator. I'm going to ask the first question, some of the questions that we've seen in the chat so far. The first question is going to be, it was asked to Mr. Corrado. Katarzyna Narovska, she is one of our most outstanding Ukrainian mediators. She is chairing the National Association of Mediators in Ukraine. And her question is as follows. How to apply cohesion through online, how to actually find agreement in the best way when working online. Are there any good tips that you're ready to share, Corrado?
Well, I think it is one of the issues, I think, of online mediation. As it is much clearer, you don't have the very same level of rapport, easiness of rapport that you have with an in-person meeting. And of course, while you can't reduce this issue to zero, you can somehow try to do your best as a mediator to anticipate the problem, to try to avoid the problem. What I could suggest with regards to online mediation is making good use of pre-mediation online meetings or in-person meetings, if possible, to start creating rapport before the mediation starts. And then some very high attention to the use of microphones, for example. While it is a kind of a general rule that we all have when we are in a meeting like we are today, keeping the microphone off, if we are in a joint session, this could really avoid us hearing to some very important paraverbal aspects, like sounds the parties do when listening to the other one, which is very important for us as mediators to underline the tridimensionality of what is underneath the surface of conflict. So what I try to do, for example, with regards to that is asking the parties of course, there are not 1,000 parties, when they are in a joint session, to keep the microphone on, trying to avoid environmental noises low as much as possible, for being able to hear all that, considering that the rest of our communication is just confined within this small stamp that we are included into, and is very limited even if we use very good microphones, camera, and lighting. So I try to address all these during pre-mediation meeting, having them connecting at best, try to meet them before the mediation starts. I try to keep hearing their sounds when they are talking. I try to use a bit more private meetings than I would do in an in-person mediation during online ones, for keeping rapport on. I would try to be careful with my gestures. So for example, now I have my hands here. If you would see me live, you would think I'm kind of an awkward person because they are right under my face. But here, perhaps you may feel like it is normal, and you see my hands, and it is more direct communication, and it creates more rapport. So I wish my hands can be visible during online meetings, and it can create rapport. And when I go, for example, with some very delicate questions to the parties, listening to them, opening up towards their emotional aspects or relational one, even if I don't see them directly, I look at the camera, and they may feel like I'm looking straight into their eyes instead of just looking at my screen, which would allow me to see them, but they would not perceive like I'm looking at them. Like small tips and tricks, trying to reduce this difficulty, but for sure it will never turn to zero. So you have to do your best for making sure the parties are involved, comfortable, can use technology at best, don't have bugs, for example, issues in using technology at all. Very good question.
Many thanks for your answer. And this issue with the hands, now I'm just thinking over how to get it. Many thanks. And we have a hand from Mr. Siddharth. Mr. Siddharth, we can unmute you. Please unmute yourself and pose your question.
Thank you so much, ma'am. Thank you so much to the panelists for such an insightful session. I'm deeply grateful to each one of them. And I would just like a response to, one of the concepts discussed by Mr. Gary. And it was on how a mediator kind of decentralizes, timelines and decision-making, especially through formal and informal channels of mediation, and how that kind of helps in corporate partnerships. I believe this was one of the discussed points. And I'd just like to know, as a mediator, what do you personally think, there are various linguistic barriers, there are various social constructs as well. So how does a mediator actually ensure that the decision-making and the timelines are structured in such a manner that the corporate partnerships are bridged to a certain extent when it comes to differences? So how does it actually pan out to be? Thank you.
That's a great question, and it's a question which deserves substantial attention. Very difficult to put everything in a few minutes response, or a minute response, let's call it. And there's no single set of things that can be done. Some of the things that I would think about employing to achieve what you're inquiring about would be among them, facilitating a dialogue across different hierarchies, using diverse formats, taking into consideration the possibility of using plenary sessions, private caucuses, and back channel communications as well. And when I say back channel, it could be that idea of assuming that we have assuming that we have a presential, an in-person mediation, by having a little chat with one key person or another during that coffee break, or when we're not all in the room together. So that can help a lot. Another thing that could be attempted would be to break down broad questions into digestible modular topics, let's call them, and to assign the topics to different working groups, which would set up according to, in fact, and through that, encourage cross-functional and cross-party collaboration. There's another thing that can be done. Did you speak with, in fact, I have to mention, thank you for asking that question, but thank you for putting it in writing also in chat. I think it was a private chat. So I'm going to take a topic. I'm not sure if you verbally did this, but in your chat question, you asked about timelines. And one of the things I would consider would be setting tiered timelines to accommodate both short-term and long-term orientation, using parallel processes and regular checkpoints to be able to make sure that everything is on track, as it were. Again, could go into a much more detail on this, take a broader view on this, yet I think we should respect the limitations of the format that we have there, but great question.
Many thanks, both of you, for the great question first and the profound answer. Our next question from the chat is about the psychological education or trainings for mediators. And first, this is the question for all the panelists. However, I would kindly ask Katarzyna to first approach it.
In my perspective, it's not essential, but something about psychology, it's needed. Yes, so as much as you can provide. But the thing is, we are not a therapist. So if the psychology is needed, we should pass to therapists, the people we are dealing with. But I think through years of experience, I mean, once as a mediator can really touch the part which is interesting from psychology to understand better yourself and the people you are dealing with. And especially when we're dealing with parties and their advocates and the relations and tensions and emotions and interests and all about the psychology in those relationships. I think it's interesting to understand it because it can be helpful.
Many thanks. And the question from my side, I will use this monopoly right of a moderator. I was listening to all of you, and what I was thinking over is that, yes, they feel these intercultural differences so sharply. Yes, they have great experience of 2 decades, each of you. And yes, it's clear. That's the experience and understanding, learning by doing. However, all of you, and mostly Gary, said you should learn about cultural differences and how young mediators, young professionals could learn about it.
If I may jump in, sorry. I think it is very easy. In fact, it's all connected with curiosity. So when we are just together with people coming from our very same town, having had the very same education and somehow the very same or very similar life experience, still we acknowledge many differences are between us. And of course, it really opens up the vision of how huge differences may be if experiences were different, cultural sources were different. And of course, it is just a matter of trying keeping this attention on and curiosity turned on as well. And it is much easier than you can really expect. You can go through a lot of reading, a lot of pre-mediation reading. You can really prepare yourself theoretically. But I would say even more important is having curiosity and attention towards people around you on.
If I may layer upon your great answer, Corrado, I think that the vehicles for doing that is to participate in programs like this one. We have a great facility for accessing other cultures, other populations throughout the world through electronic communications means that I dare say that Corrado, Katarzyna, and I did not have when we first started out here. So I would seek out opportunities, programs like this, participate in various international competitions. We have the CDRC coming up in Vienna in 2 weeks time, I believe. It may be a little bit late to volunteer to be a judge or another volunteer for that for this year, but there are other competitions like that in which there's a real engagement among students and their coaches and judges, faculty, etc., where there's a real mixture of cultures, and you can really see things play out in ways that once you think about it with that curiosity mindset that Corrado mentioned, it was good. I understand this, and it can help to create an awareness of cultural divergence and make the individual fluent, or at least conversant in the complexities of different cultures and how one might diverge from another.
Many thanks, dear Katarzyna. How to become a good multicultural mediator?
It's a great question because I don't know the answer. I think the process of becoming mediator, it's a process, it's a path of life. And you never, I feel I'm never gonna be a good mediator in that context. And cross-cultural mediation, every mediation is different. So what Gary said, it's about, and Corrado said, it's about curiosity and openness for meeting other people, for understand, for listening to them, and reflect everything we get to know every minute, every time we had that possibility, and then just going on the path. It's a path. We had many of us had the same mentors, and they're quite old, and I think they still think the same. The next mediation would be the next curiosity moment. So I think curiosity and self-reflection. Never be too sure that you know anything. So beginnings mind and not judgmental, and being in a moment, here and now, present with the parties. That brings you more trust from them. So.
Many thanks, dear Katarzyna. Dear participants, dear panelists, we've run out of our time. However, we spent these 2 hours absolutely fascinating for me. Before, I was wondering and thinking that I have read about these issues, and now I do understand that I have not known so much before this session. I'm very grateful for the audience, for the Ukrainian Academy of Mediation team for making this panel possible. Stay in touch and see you on another activities at this forum. Have a nice evening. Once again, many thanks.
Thank you. Thank you.
Thank you, Nataliia.